My name is Tola Onayemi. I work at Norebase. Norebase is a single platform that allows you to do business around the world. The idea is that we can help you start, scale, and operate in different markets from one single dashboard. So that means that in any market that you operate, we can help you get set up, your trademarks, we can help you with your ongoing compliance. And the idea is that we believe that people should not have to struggle with providing services to their customers around the world. You should be able to find their customers wherever their customers are, because we can help them get operational in those markets. And thank you for your question, and I'm excited to be here. I think that one of the big hallmarks of the Arbitration and Mediation Act of 2023, particularly for the tech industry that I'm part of, is the cost reduction, right, which is a big point. So prior to now, one of the things was that if you did not have a number of arbitrators designated, or right, the minimum that would be designated was about 3. Now, while that seems fast, the problem is that there's a cost implication. There's also a time implication to dealing with 3 arbitrators. Usually one will be chosen by yourself, one by the other party, then the last by 2 of you. So there's a cost component to that, there's a speed component to that. It just takes a bit of time for businesses. And as a business person, you're just trying to get business closed. You're just trying to move fast with business, right? And so disputes, I like to say that disputes are like speed bumps in like making economic activity happen, right? And so businesses just want to get past it as quickly as possible. And so that cost reduction is a big amplification of why people would lean towards using the AMA one. The other second is confidentiality. A number of times when you have disputes, you want to keep it as confidential as possible, right? Like you don't want it on the tabloids, you don't want it on the press, you don't want to distract your investors, you want to distract your customers, because it has ripple effect, right? Especially in the tech space where you're trying to be disruptive. And that means that a number of times you're already trying to do very innovative things that customers, you're trying to do a lot of change management for customers, right? And so you don't want to have to deal with the fact that now it's in the press that you're having this dispute, right? And so one of the big things with arbitration also and mediation, right, is that idea that you can keep things confidential. For instance, court records are official public records, right? And so when it's a court record, anyone can subpoena the records, anyone can read. It's a public record. But arbitration allows you that level of confidentiality. I think also expertise, right? So one of the things that people have said over and over again is that you want people that are experts to be the one to make decisions on matters that are very technical. Today, while the courts have great judges, the thing is, when you start to deal with the nuances, e.g. intellectual property issues, right? When you think of startups, a number of times you find that there's IP is a big issue for them. Intellectual property, whether it's trademark, whether it's patents, whether it's like industrial designs, and right, and that thing that is also business models. We tend to be trying to innovate around our business models. We're trying something new that no one has tried before, and in some cases also that we use template agreements because we want to move as fast as possible. The thing here is that lawyers and judges are used to interpreting things in a very specific way, but in the legal environment for tech is dramatically different. For instance, we all use safe agreements. Safe agreements are not standard investment agreements, right? Safe agreements means that it's called a simple agreement for future equity. So what happens is that someone is investing and saying that I will get my equity at a future price round. Now that's not something that law firms or even judges are used to. So if I say something like, oh, you don't have any shares in this company because you invested by a safe, what does that mean if there's a dispute that arises out of that safe? Those are kind of things that automatically come up. You want someone that's technical, that has context and has prowess in this to actually have to deal with. And so yes, I think that there's a lot of like strong advantages to the AMA 2023 for like the tech industry. And just that idea that you can get someone technical to deal with issues. But I think even beyond the speed, technical, privacy, and it's also the idea that today, one of the big reasons why a lot of tech companies are registered in the US or in the UK or jurisdictions outside Nigeria is that investors want a level of confidence of non-partiality and non-bias, right? And most of them feel like they feel more confident with the US legal system or the UK legal system. And one of the things that arbitration allows is that it allows you to say, well, designating this level of people who have this level of credibility. And so I'm not as scared about bias. I'm not as scared about having to deal with issues of partiality. And I think that's also a big thing for like businesses and investors today. I think another thing that comes out very clearly to you for people in the tech space particularly is the level of nuance that goes into how the product is designed, right? So for instance, you want someone who understands the nuance of your product. Well, for instance, if I'm a buy now pay later product, right? How different is that from a credit product, right? And what are the different terms? And how is that different from, say, a product that is designed around like Sharia lending, right? Those are like Islamic banking. Those are like dramatically three different products, right? And they have like tiny nuances that you need to understand, either from how their models are distinct. For instance, what's the distinction between a SaaS product, right? A software as a service product, and a product as a transaction product, and a product that is a marketplace, right? And what happens when it's a software marketplace? That gets a lot more common. You want people that have that level of nuance to deal with the issue, and it gives business people in the tech space a lot more confidence to know that someone that has nuance and understands their space is always making decisions, or at least trying to help resolve disputes when they come up. I think that's a very good question. I think there's a number of things that you can do. I think one of them is actually engaging more with that industry. I think that today, there's not as much engagement between the arbitrator market and the tech space. I think what happens today is that we engage when there's a conflict, right? But I think what you want is to ensure that there's more engagement before conflict even happens. So meaning, how can we spend more time trying to understand the legal space? And also just understanding incentives, right? I think the business in the end is a game of incentives. Like, what do you care about? For instance, and I can give a very interesting example. Today, if I raise a lot of capital as a venture-backed company, right, I'm trying to grow really fast because I'm looking for how to solve a problem, because I think there's a probable exit in the past, in the future. It means I may not be profitable. It means I'm plowing back money into the business. A traditional business person cannot understand why you're running a business and not trying to make profits. Why are you trying to grow at all costs, right? That's clear incentive distinction can be the difference between how someone thinks about a judgment, right? It can be an issue of saying, so for instance, someone says, an investor comes and says, this person is wasting my money, right? And it's just like trying to destroy the company, or it's just being a wasteful spender. And that happens a lot. And I think I see it a lot even in articles, when articles get written by tech blogs or blogs about tech businesses. You see a clear distinction between how people will understand the incentive of a tech founder that is venture-backed, and the incentive of a tech founder that is private equity backed, or the difference between the incentive of a tech founder that is bootstrapping. They're just different incentives. And I think understanding that incentives helps you understand how do you interpret their actions in court. For instance, it's not abnormal to see businesses that are trying to grow at all costs spend a ridiculous amount of money just to acquire customers, right? Now that can look like wasteful spending in a bootstrapped market or for a private equity business, but it's not ridiculous for a venture-backed business. And I think that kind of engagement more than ever helps people understand that what's their incentive? Their incentive is to grow at all costs, to prove whether this market is big enough so that now they can think about acquiring. And the idea is that marginally we'll make money over time, but the idea is to grow. For instance, I was reading yesterday that Uber just started making profit, I think last year, for the first time since they were set up. Right now, that is context that only a venture-backed, someone understands how venture-backed businesses are designed can work. So I think engaging more than ever is like one of the big things that you can do. I think the second thing is also just getting the technical chops, right? Meaning trainings, official technical trainings. Now, there's an incentive to want to do more of those technical training for like very established fields, marine, banking, financial services, the more established ones that pay a lot more money, right, than for tech. And the reason is because there's also important to understand that tech in itself is more a means to solving problems than an industry in itself. And this is what I mean. There is tech for marine, there's tech for legal, there's tech for finance, there's tech for fintech, there's tech for credit. Because in the end, what it is that technology is, how do I do more by creating systems that technology can help me? So yes, like I'm saying, so tech basically is a way of doing things, right? The idea of technology is that I can do more by the automation and by creating systems and allowing technology to help me do more. And what that means is that any sector can be improved with technology. Technology is basically fundamentally a way of doing things in a better way, right? Now, once you start to think in that way, what it starts to mean for you is that for every sector you can think about, there's technology for it, right? Or there's the way technology can apply it to it. Now, thinking about that helps. It means that an arbitrator or a mediator who's going to deal in the technology space needs to not only understand the technical chops for the base industry itself, he also has to understand the incentives for the business models for technology. He has to understand how technology is being applied here. And so not only must you have technical knowledge on the base industry. I'll give you an example. If you're going to try to do arbitration for a fintech, you need to understand financial services, how it's organized in the first place. Then, how the incentive and the business models that exist for fintech specifically, and then how technology is solving the problem here. And that could mean a number of things. It could mean things like, what's the role of data protection in all of this? What's the role of intellectual property? What's the role of algorithms determining who's eligible to credit and who's not eligible to credit? All that is, so for instance, someone were to sue tomorrow and say, I was being discriminated against, right? Why did this person get credit and this person didn't get credit? You need to understand all those incentives to be able to make a determination of, was there a right decision or a wrong decision? And so, and I think so, like I said, getting more technical knowledge of the space. I think beyond even those two things, I think it's also, we need a lot more arbitration and mediation that's designed and adapted for like tech businesses. So tech businesses want speed, but they also have a lot of like peculiarities. One of those peculiarities, for instance, is that they generally tend to be very disruptive, right? Meaning they always question the status quo. Now, the question is, you don't want to have to go to an arbitrator or mediator who has a very entrenched way of thinking around how the world should work, right? Because what that automatically means that you're already set on the back foot. And so there's a lot of those kind of things you need to deal with, and which is one of the reasons why tech companies do not want to go to court systems sometimes, right? Because you're having to deal with someone who this is how the world works, right? And someone is saying, I don't think the world should work this way. I think we should question those order and think of new ways of doing things. And so you want to be able to think about that nuance of, right? And one of my favorite quotes is that someone that says that every tech entrepreneur is a crazy person, because why do you think you're so special that you can change the world? But that's the very makeup of someone who is trying to use technology to solve big problems, right? They're thinking that you can question how things work, and you can and so I think just more engagement and more adapting arbitration. And that could mean a number of things. It could mean things like, it's almost like how today you have like plug and play legal agreements for tech businesses. You have the safe that's not been done. You have, even in investing, and you now have things like accelerators that are designed for tech businesses. You want to do the same thing with arbitration. Someone saying, this is a problem, and adapting something to solve that specific problem. Today, the very popular structure of how most companies are set up is that there's a US company, a UK company, and a subsidiary company in Nigeria, at least for most Nigerian businesses that are in tech. The reason is that you're going to go raise money from the US, and US investors have confidence in the US legal system. But that's also very expensive, because it means now you're dealing with a US holding company. It also means that you're going to deal with some minimal taxation in the US, or at least some exposure to the US legal system. Right. It also means that now you have to maintain this company that you don't need for operational purposes, but just for the sake of being able to receive capital. The big question becomes, what does all that look like if investors had more confidence in the Nigerian legal system, or at least in the arbitration system, and can say, just have one entity, deal with this entity at least till you're ready. That changes the cost. It changes how much mind share business has. For instance, today, you need to set up a US company, get US banking, put your money in the US. Just a bunch of nuances you need to do that you probably shouldn't have to deal with if you were American, right? No American is setting up a Nigerian company just for the sake of having an holding company, right? And that's like an interesting thing around investor confidence. But I think more than anything, I think so today there are 4, 5, 6 conflicts that usually happens with tech companies. One of them is co-founder disputes. The second big one is disputes around intellectual property and the technology that's been applied. A third big bond of dispute is disagreement with investors on different terms. And the last one is exit disagreement. So I could have an exit, maybe it's an IPO or someone wants to acquire, and there's a disagreement on that. Now, in each of those cadres, just having what arbitration offers to you is speed, but beyond speed, it also offers to you someone who is technical, but it also offers to you a cost that works, right? Especially in the context of all their amendments. So for instance, one of the interesting things about the new Arbitration and Mediation Act is that it actually clearly spells out that if it calls out an online dispute settlement system, it calls out very clearly there's an electronic system for receiving documentation and all of that. So what it means is it moves more towards the disruption and the innovation that should exist. But I think that also means that it's just speed. It means that the speed bump to making economic activities happen can be reduced and can just be easily more faster. But I think that also is that you can So when people go to courts, it generally gets very adversary. You pay this lawyer who is like expensive, and I have no problem with that because I'm a lawyer, right? But the point is, you pay this lawyer who is very expensive to come and then defend you. And it's natural by itself adversary. So what ends up happening is it kind of splits the relationship between the two parties, right? It also instinctively just ruins the relationship between the two parties, right? I think that one of the advantages of arbitration and mediation is that you, especially when if you've done well, imagine a case where you have a sole arbitrator, someone who's professional, someone that tries to be as conciliatory as possible. You could end up in a situation where, because the two people who are in partnership in the first place are in partnership because they both want to do business and because there's an economic advantage to being in business together. What might be interesting is, how can I preserve that relationship while resolving the dispute between them so they can get back to how they were making money and making economic partnerships happen in the first place? And that's another big thing that can happen, where someone resolves the issue a lot quicker for you, in a smoother way, and because of that you can go back to and it happens all the time, right? People have disagreements all the time. People have disagreements and come back to do business years after. And you want to be able to preserve the ethos of that relationship while trying to do all these transactions that happen. So I think that's some of the things that my thoughts about how it can help preserve. And also, even when you think about innovation, right? So today, intellectual property is a big part for most businesses, right? But the big question is, how many people understand the complexity that goes into those intellectual property, right? For instance, there's this whole language around who owns what, right? Is the IP created owned by the company, or is it just something that the company owns in the course of business? Cases where someone else owns the IP, but the company has has a permanent license to use it. There's a bunch of nuances like that. There are also issues like what happens when there's conflicting marks. Two of us have similar trademarks, or two of us have two people come up with similar ideas at the same time. There's a bunch of interesting things that could come up. And what you want to be able to do is resolve those things faster in the least intrusive way, and to get back to doing business. And I said this, I think that the world progresses by people solving hard problems.